Yeah, Mr. Singh. Pani pilau.
Milord's, the impugned order, Milord, is dated 21st of January 21, and I straight away take your lordships to to page 5, Milords. Milord, this the whole issue arises out of section 18(5).
On the mic, sir. You'll have to speak on the mic. It's not of a good quality, I do admit, but then you'll have to do something about it.
Milord, the matter arises out of section 18(5) of the Bihar Panchayat Raj Act. Removal. Now, Milords, the judgment does quote the 18(5) in its.
Now, see, we are not in agreement with the order of the single judge.
Milords.
We are not. That's not a misuse of position. We prima facie find that out of the 3 charges, 2 could not be proved, and the third one will not come in the category of the application of 18(5). But before that, you must tell us 2 things. Now, what is the current status of this Mukhiya?
Milords, as per the interim protection which was given to him, he did run for the elections, Milords, which just got over. He could not succeed, and that is as regards Milords 18(5), that proviso that he'll not be allowed
for 5 years, next 5 years.
For next 5 years, Milords, that is taken care of. But Milords, the stigma is there, and therefore, Milords, I am pursuing with this letters patent appeal. Otherwise, Milords, frankly
speaking, it doesn't help you out.
Academic.
So far as your assignment as Mukhiya is concerned, you lost it. And 5 years term would be there for Mukhiya, and this stigma also would not attach to you thereafter.
That's right. But the stigma is there, Milords, only to that extent.
Yes.
Your Lordship, in the appeal, he has pointed out that we have not been served notice and the order has been passed.
These issues we don't discuss unless it is for the benefit of the person approaching the court, that he has not been noticed and therefore no order against him can be passed. Yes. Now, assuming everything to be correct.
Yes.
Now, what is this third charge?
Well, that your Lordship will find.
And but Mr. Singh, look at the nature of the type of typed copy or photostat copy that you have supplied. We can't read anything out of it. It's all blackened and blurred.
I'm so sorry, Milords, that is because the online
My brother has a better copy, I can borrow it from him.
Milords, the one charge.
He has a better copy. At least he can read.
Yeah.
आप तब तक इसको देखिए. अच्छा छोड़ देख. Yes.
Milords, one charge which.
Read the charge number 3.
Milords, the charge.
No, which charge could not be proved?
Milords, the charge, the 2 charges which could not be proved is Milords at page 44. If my lords will permit me, I'll read it, my lords. The second paragraph at page 44, my lords. जांच दल के संयुक्त जांच प्रतिवेदन के में योजना संख्या 100 के संबंध में प्रतिवेदित है कि मुखिया एवं कार्यक्रम पदाधिकारी के द्वारा बताया गया कि इस योजना के नाम में त्रुटि होने के कारण
आप कहां पढ़ रहे हैं?
पेज 44 में लोग सेकंड पैराग्राफ,
which begins 1 2 3, 14वीं वित्त आयोग की योजना संख्या, वो पढ़ रहे हैं आप?
नहीं,
कहां पढ़ रहे हैं? Are you having some other order with you? That is the only Hindi wording.
Because I am reading the impugned order of the.
We are looking at the impugned order, sir.
Then at page 44, my lords.
44, internal page 2 of the order.
No, my lords, it would be 3, 4.
There is no Hindi paragraph here. There is no Hindi paragraph here except the one which we can find.
Annexure 9, my lords. Annexure 9, page 34, starts at page 34.
Show him the order. Let us see whether he has the same order with him. Dikhao sir.
I'm sorry, my lords.
No, we are inclined. 2 of the charges could not be proved. The third charge that he used bricks instead of soul bricks, brick pieces.
My lords. For
we,
that, Miloj, for that what happened was,
we find that it is not such a misuse.
Miloj,
18.5 should not have been applied. That's a different order that you are referring to. आप इम्प्यून ऑर्डर पे आइए, छोड़िए वो पहले क्या है।
Sir, about Annexure 9 part has that was in
Supply us a freshly typed copy tomorrow, we will hear you out.
then let it be day after, Miloj.
No. It's something which has lost its utility. You are talking of a stigma, we will deal with it. Even if we don't interfere with the order, we'll say that it will not act to your prejudice.
Absolutely, Miloj.
We can do that.
Lordships can do it right now also, if Miloj is inclined.
No, we'll have to deal with the law.
Okay.
We'll have to deal with the
Miloj,
law.
page 44 I was pointing out.
This is not the impugned order, no?
This is Annexure 9.
In an appeal, the impugned order is the order of the single judge.
Oh, that is there. That is there. I'm reading the impugned order in the writ application.
All right,
Annexure
so you
9.
have said that, yes.
Yeah, I'm sorry, my lords. That at page 44, if my lords will see.
Yes.
My lords, the two which was not established, the charges two which, my lords, I'm reading the second paragraph. जांच दल के संयुक्त जांच प्रतिवेदन में योजना संख्या 100 के संबंध में प्रतिवेदित है कि मुखिया एवं कार्यक्रम पदाधिकारी के द्वारा बताया गया कि इस योजना के नाम में त्रुटि होने के कारण भ्रम की स्थिति पैदा हुई है एवं वास्तव में मनरेगा से अलग योजना तथा 14वीं वित्त आयोग से अलग योजना दोनों अलग अलग स्थल पर कराया गया है। संयुक्त जांच दल के प्रतिवेदन में योजना संख्या 100 के संबंध में ये भी उल्लेख किया गया है कि जांच के दौरान ईंट सोनिंग के कार्य अलग कार्य कराया पाया गया है, अतः योजना संख्या 100 के संदर्भ में जिला प्रशासन का आरोप निसंदेह रूप से स्थापित नहीं हो पा रहा है। Now this take care of the 2-2.
तो पहला और दूसरा दोनों डिसाइड हो गया ना
जी,
लेकिन बिना कार्य कराए ही सरकारी राशि की निकासी कर ली गई है जो गंभीर, ये कहाँ है, इसके बारे में कहाँ है?
ये इसी में है हुजूर, निकासी कार्य हुआ है। दैट इज व्हाई दे आर सेइंग दैट दो योजना है, दोनों में कार्य हुआ है, दोनों का नाम अलग है, इसलिए वो कंफ्यूजन पैदा हुआ।
नहीं, कम टू पैरा 10.
मिलो,
This is what I wanted you to tell us. Therefore we will not be giving a specific order,
मिलो,
setting aside the order of removal. Otherwise we'll say that now that it borders on confusion and therefore there should be no stigma. Otherwise also 5 years have passed by.
मिलो,
I think that will satisfy you.
I'm satisfied।
Otherwise you read this.
मिलो, it is there।
पैरा 10
दुराचार के श्रेणी में आता है,
तो वो पढ़िए ना, उसके बारे में क्या लिखा है?
उपयुक्त, आई रीड द होल पैराग्राफ।
Yes.
उपयुक्त कंडिकाओं की विवेचना से ये स्पष्ट निष्कर्ष निकलता है कि श्री अख्तर अली मुखिया काजीपुर ग्राम 100 सरकार के निर्देशों का अवहेलना की गई है, गलत नियत के से सरकारी राशि की निकासी की गई है तथा योजनाओं का क्रियान्वयन का लोक निर्माण समिति अथवा स्वयं के द्वारा कोई पर्यवेक्षण नहीं किया गया है। मुखिया द्वारा पंचायत सचिव के साथ आपराधिक षड्यंत्र कर लोक राशि का दुर्विनियोग किया गया है। उनका ये कार्य अपने कर्तव्यों के निर्वहन में स्निहित शक्तियों के दुरुपयोग का द्योतक है तथा दुराचार की श्रेणी में आता है। इस प्रकार आरोपित मुखिया के विरुद्ध बिहार पंचायत 18/5 के अंतर्गत
We'll take care of it.
This is more or less a summing up of every allegation, my lords, and bringing me under section 17, my lords, of the act, which are the duties of the mukhia.
Again, heard Mr. Sanjay Singh, learned senior advocate for the appellant, and Mr.
Manish Kumar, AC2 AG6.
and Mr. Manish Kumar for the state,
Yes.
whoever junior you are. We acknowledge only the person who stands before the court. And Mr. Manish Kumar, the counsel for the state. Invoking the provisions contained in section 18 subclause 5 of the Bihar Panchayat Raj Act 2006, the appellant was removed from the post of Mukhia of Kazipur Gram Panchayat in Simri block in the district of Buxar. Stop. 3 charges were leveled against him, namely the work executed under 2 different schemes were not according to the proposed plan, semicolon, at one spot, comma, two projects were shown to have been carried out for which money was withdrawn, and lastly that they, they, there was financial irregularity in withdrawal of money without observing necessary formalities or getting an inspection done by public construction committee before before concluding the project work. The aforesaid order of removal passed by the Principal Secretary, Panchayati Raj Department, was sustained by the learned single judge by its order dated 21/1/2021, passed in CWJC number 4559 of 2020. Mr. Singh, learned senior advocate for the appellant, has drawn the attention of this court to the fact that notwithstanding that the learned single judge found that 2 out of the 3 charges could not be established, but sustained, but the order of removal was sustained on the ground that one of the charges could not be disproved by the appellant. He further submits that in the last instance, when the order of removal was passed, the report which was submitted by the district magistrate after an inquiry at the on the asking of the principal secretary of the department, copy of such report was not served upon him for him to effectively defend himself. Lastly, it has been submitted by the appellant. Lastly, it has been submitted by Mr. Singh that assuming but not admitting the fact that there was some irregularity in the withdrawal of money or its use, it would definitely make out a case of misconduct entitling the authorities to exercise the powers under section 18(5) of the Panchayati Raj Act. He further submits that section 18(5) of the Act clearly reflects that only in certain exceptional circumstances conceived in the provision, such an extreme step of removal of a mukhiya could be directed, and those conditions are that the mukhiya absented himself on 3 consecutive meetings of the sitting of panchayat without any sufficient cause, or he willfully omitted to or refused to perform the duties and functions under the act, or abused the power vested in him, or was found to be guilty of misconduct in the discharge of duties, or had become physically or mentally incapacitated for performing his duties, or had been absconding after having been made an accused in a criminal case for more than 6 months. It has been urged on behalf of the appellant that abuse of power or misuse of power are serious charges which cannot just be saddled on anyone for justifying his removal from the engagement. It would be highly unreasonable and inappropriate to dub every act of a public functionary to be an abuse of his power or misuse of power. The positive intentional misconduct is an important ingredient in holding any act or omission to be an abuse or misuse of power. The 3 charges against the appellant were interlinked and the order passed by the principal secretary clarifies that because of some confusion with respect to the two different schemes at two different times, such charges were leveled. Stop. The only thing which was found to be in aberration of the established principle of executing such work was that the withdrawal of money and the consequent use in carrying out the project was not vetted by a committee which was required to oversee the correctness, which was required to oversee oversee such expenses. Mr. Singh, learned senior advocate, therefore submits that if two of the cognate charges were found to be non-existent, the third charge, namely the charge on which the power under section 18(5) of the Act was invoked, fell to the ground. He further submits that the report ought to have been afforded to him. The report against him ought to have been afforded to him for justifying justifying his removal from the post of Mukhya. This court has been pointed out to this court that considering the fallacy in the order passed by the principal secretary as also the learned single judge who sustained the order, a coordinate division bench stayed the operation of the order, perhaps for allowing the appellant to contest in the next election of Mukhya, which he otherwise would not have been able to contest for the reason of his having been punished and removed from such engagement under the provisions contained in section 18 subclause 5 of the Bihar Panchayat Act so and so year. The Land Council for the state, on the other hand, submits that the appellant contested for the post of Mukhya in the next term, but lost. The stigma, if at all, would have attached to the appellant would last only for 5 years and not further. Thus, any discussion on the order of removal or the order of the learned single judge would be academic. Be that as it may, since we have found that the order of removal of the petitioner from the engagement was bad in the eyes of law, and we also do not find that the order passed by the learned single judge took note of the aberrations which have been noted above, we are inclined, even for academic purposes, to set aside the order passed by the learned single judge and consequently the order passed by the principal secretary of the department. We make it clear that such order has been passed even when today it may not be required. We make it clear that this order has been set aside. The order is set aside. The appeal stands allowed accordingly.
Blessed.
We are not saying it for the purpose that it is only for removing the stigma, otherwise it would be a cockeyed looking at the things. So we set it aside.
Obliged, my lord.